Case summary: Krell v. Henry 1903 Court case. Krell v. Henry 1903 2KB 740 Court. King's Bench Division Judge Lord Justice Collins. Background facts: Claimant, Plaintiff, Charles Krell. Defendant, William Henry. Event: Coronation of King Edward VII. Facts: Charles Krell, the claimant, owned a flat at 56 Pall Mall, London. William Henry, the defendant, agreed to rent the flat from Krell for £75 per day during the coronation procession of King Edward VII. The main attraction was the procession passing along Pall Mall, visible from the flat's windows. The contract was explicitly contingent upon the procession taking place along Pall Mall on the specified date. Arguments: Claimant's argument. Krell argued that the contract was frustrated because the main purpose of the agreement viewing the procession was frustrated by the cancellation of the procession along Pall Mall due to the King's illness. Defendant's argument. Henry contended that he should not be liable to pay the agreed rent because he did not get the benefit of the flat's main attraction, the view of the procession. Final outcome: decision. The court held in favour of Charles Krell. Lord Justice Collins ruled that the contract was frustrated due to the unforeseen event, the cancellation of the coronation procession along Pall Mall. Therefore, Henry was not obligated to pay the rent for the flat, as the main purpose of the contract was frustrated by the event outside the parties' control. Law justification. The doctrine of frustration applies when an unforeseen event occurs after the formation of a contract, making it physically or commercially impossible to fulfill the contract, or transforming the obligation to perform into something radically different from what was originally contracted. Lord Justice Collins emphasized that the rental contract was contingent upon the specific event of the procession passing along Pall Mall. The frustration of this purpose rendered the contract void, relieving Henry of the obligation to pay rent. Key concept implications. Krell v. Henry established the doctrine of frustration in contract law. It illustrates that a contract may be discharged if an unforeseen event occurs that makes it impossible to fulfill the contract or fundamentally changes the nature of the obligations. Key learnings. Doctrine of frustration. Contracts can be frustrated by unforeseen events that fundamentally alter the contractual obligations. Purpose of the contract. The frustration must go to the root of the contract and not just inconvenience one party. Non-occurrence of an event. Frustration can occur when an event necessary for the performance of the contract does not take place. Allocation of risk. Frustration allocates risk between the parties where performance becomes impossible due to events beyond their control.